होती, या रिस्क की नॉलेज ही केवल सफिशिएंट नहीं होती जानना, ठीक है। इट इज फ्री कंसेंट इज मोस्ट ऑफ द इंपॉर्टेंट। नेक्स्ट, एक्ट ऑफ गॉड, मोस्ट इंपॉर्टेंट, जो लाइक मोस्ट ऑफ द पीपल आर फैमिलियर विद दिस इज अ मूवी ऑफ ओ माई गॉड, द मूवी ऑफ ओ माई गॉड। क्या था? वेस्ट मेजर, पोलक, an operation of natural forces so unexpected to anticipated। essential क्या क्या थे? There must be working of natural forces like exceptionally heavy rainfall, storms, tempests, earthquakes, tides, and volcanic eruptions without any human intervention, किसी भी human intervention की चीजें। The occurrence must be extraordinarily, the occurrence must be extraordinary and not one which could be anticipated and reasonably guarded against। Force measure literally superior forces. Which kind of forces? Superior forces is a term of wide import and includes act of God, war, right, strike, earthquake, etc. Meaning irresistible force or compulsion or circumstances beyond one's control। द मोस्ट इंपॉर्टेंट यानी मोस्ट फेमस केसेस कौन सा है केस लॉ? निकोलस वर्सेस मार्शलैंड, निकोलस वर्सेस मार्शलैंड, केसेस ऑफ 1876। क्या था इस केस में? द डिफेंडेंट क्रिएटेड आर्टिफिशियली, देखो कौन सा क्रिएट किया? आर्टिफिशियली क्रिएट किया, ऑन हिज लैंड once theater was an extraordinarily heavy rainfall, as a result of which overflow of water from lakes washes away four bridges belonging to the plaintiff, held that defendants were not liable as the loss had occurred as a result of act of God। Now we'll see inevitable accident, इनएविटेबल एक्सीडेंट इन शॉर्ट फॉर्म ऐसा एक्सीडेंट जिसमें आप इस एक्सीडेंट को प्रिवेंट नहीं कर सकते थे, ठीक है। पढ़ते हैं इसको, देखते हैं क्या है। एक्सीडेंट शुड नॉट हैव बीन कैपेबल ऑफ बीइंग प्रिवेंटेड बाय ऑर्डिनरी स्किल एंड डिलीजेंस। पे अटेंशन ओवर हियर, द वर्ड्स आर ऑर्डिनरी स्किल्स एंड डिलीजेंस। Defense is available only if the accident occurs during the prosecution of a lawful act and not when the act done is unlawful। कौन सा प्रोसिक्यूशन होना चाहिए? लॉफुल एक्ट का, ना कि when the act done is unlawful। The case law is Stanley versus Powell case, Stanley versus Powell case। Both the defendant and the plaintiff were members of the shooting party, the plaintiff and the defendant were the members of the shooting party and went for peasant shooting। The defendant aimed at the peasant, but the shot glanced off an oak tree and hit the plaintiff। The defendant was held not liable, defendant will be liable ठहराया नहीं गया। Next case law is Holmes versus Mather, Holmes versus Mather। If the driver isn't able to control the horses in the public highway, which are startled by a barking dog, and the plaintiff is thereby injured, the defendant will not be liable, the defendant will not be liable। आगे देखते हैं। Plaintiff the wrongdoer, अगर plaintiff ही wrongdoer निकलो तो extirpi causa non order actio, extirpi causa non order actio। From an immoral cause no action arises, ठीक है। नॉन मीन्स नो, एक्स मीन्स फ्रॉम एन इमोरल कॉज नो एक्शन अराइजेस, एक्सटर्पी कॉज अ नॉन ऑटर एक्शियो। Pollock, the mere fact that plaintiff himself is the wrongdoer doesn't entitle him from recovering the loss which he suffers unless some unlawful act or conduct of the plaintiff is connected with the harm suffered by him as part of the same transaction। Next case law is your Bird versus Holbrook, Bird versus Holbrook, spring gun case, spring gun case। The trespasser on defendant's land is entitled to claim compensation, is entitled to claim compensation for the injury caused by spring guns set by the defendant without notice in his garden. आप इसको हिंदी में भी पढ़ सकते हैं, ठीक है। नाउ वी हैव द प्राइवेट डिफेंस। प्राइवेट डिफेंस कैसे करें? द लॉ परमिट एक्ट द यूज ऑफ रीजनेबल फोर्स, ये बहुत इंपॉर्टेंट वर्ड है, रीजनेबल फोर्स, टू प्रोटेक्ट वंस पर्सन और प्रॉपर्टी। आप खुद को बचाना हो या अपने प्रॉपर्टी को बचाना हो, यू हैव टू यूज अ रीजनेबल फोर्स। एसेंशियल्स क्या क्या हैं? देयर वॉज एन इमिनेंट एंड immediate danger. The force employed was not out of proportion. The force is employed only for the purpose of defense. Defense के purpose के लिए होना चाहिए। केस लॉ क्या है? बर्ड वर्सेस हॉलब्रुक, फिक्सिंग ऑफ ब्रोकन ग्लास और स्पाइक्स ऑन वॉल और कीपिंग ऑफ अ पियर्स डॉग कैन बी जस्टिफाइड। ये सब जस्टिफाइड है। फॉर द प्रोटेक्शन ऑफ द प्रॉपर्टी, प्रॉपर्टी के प्रोटेक्शन के लिए आप रखिए, जस्टिफाइबल है। बट फिक्सिंग अप स्प्रिंग गन्स, आप स्प्रिंग गन रख लो, विदाउट एनी वार्निंग, किसी वार्निंग के लिए, टू अ ट्रेस पासर ने शूट कर दिया स्प्रिंग गन से, और लाइव इलेक्ट्रिक वायर लगा दिया, ठीक है, टू कीप द ट्रेस पासर अवे। द केस लॉ इज चेरुबिन जॉर्जिया वर्सेस स्टेट ऑफ बिहार, कांट बी जस्टिफाइड। ये सब चीजें, इलेक्ट्रिक वायर लगाना या स्प्रिंग गन से शॉट करना इज नॉट ए जस्टिफिएबल, ठीक है, without you are putting the warning or something information. Now I would like to exaggerate this. RRN Ramalinga Nadar versus V Narayan Reddy, 1970. Defendant has undertaken the transportation of goods on behalf of the plaintiff के behalf पे, during the transportation of goods, जब goods का transportation होता on behalf of the plaintiff, during the transportation of the goods on the behalf of plaintiff. Now what happened? Plaintiff subsequently filed a suit against the defendant, right? Because during that transportation, an unruly mob intercepted the truck and forcibly took away the goods. That is why what happened? A plaintiff subsequently filed a suit against the defendant. The defendant, in his defense, argued that the robbery was an act of God. उसने क्या बोला? ये act of God है, and hence he could not be held liable for the loss. The defendant contended that the act of the unruly mob was an unforeseen and irrespectable event beyond his control, and therefore he should be exonerated from any liability. The court held the defendant liable for the loss of the goods and ordered him to pay compensation to the plaintiff. Court noted that are carriers carriers are generally held responsible for safety of goods entrusted to them during transportation and cannot escape liability by simply attributing the loss to an act of God. आप सब चीज के लिए एक्ट ऑफ गॉड को, गॉड को रिस्पॉन्सिबल नहीं ठहरा सकते, इट इज एक्ट ऑफ गॉड, तो आई वोंट बी लाइबल, इट इज नॉट पॉसिबल। देखिए, मनिंद्र नाथ मुखर्जी वर्सेस माथुरदास चतुर्भुज 1964। इसकी इस्लाम में क्या था? Defendant, the owners of a certain cinema, had put up a huge hoarding at a crossing. The hoarding was many feet long and consisted of iron poles. During a severe storm, a banner on the hoarding collapsed and fell on the plaintiff's head, causing a severe injury. Held it was pure negligence and not an act of God. ये कोई act of God नहीं था, because it wasn't properly fastened. The fact that the velocity of the wind, which caused the fall of the banner, was less than 27 miles per hour in the city of Calcutta during monsoon season itself showed that the defendant was guilty of negligence. Same thing is written in Hindi also. जैसे हिंदी में पढ़ना है, आप हिंदी में भी इसको देख सकते हैं. You can take even the screenshots of this. आप इसका स्क्रीनशॉट भी लेते चलिएगा. Now, same thing is written over here in हिंदी, आवश्यकता, और इसको इंग्लिश में हम समझाता हूँ, necessity. Necessity, just necessities. An act causing damage if done under necessity to prevent a greater evil isn't actionable, even though harm was caused intentionally. Defense of necessity applies to cases of public necessity. A person's own individual welfare can be placed in jeopardy for the public goods. Salus populi suprema lex. Salus populi suprema lex. The welfare of the people is the supreme law. The welfare of the people is the supreme law. This terminology explains, the legal terminology explains that the welfare of the people is the supreme law. The case law is on this. Crick versus Georgie. Crick versus Georgie. क्या था? On the death of X in a state of delirium, tremens, his sister-in-law removed X jewelries from the room where he lay dead to another room where she thought they would be safer. However, the jewelry was stolen by some unknown persons, held that she was liable. उसे liable ठहराया गया. As was no proof, कोई proof नहीं था, that her interference was reasonably necessary. भूल, we can say in Hindi we have written over here, like it's already been mentioned over here. ठीक है, और इसको हम लोग इंग्लिश में देखते हैं. That is mistake. What is this mistake? क्या ये mistake, whether of fact or law, mistake या तो fact का हो या तो law का हो, is generally no defense to an action of tort. कोई डिफेंस नहीं है एक्शन ऑफ टॉर्ट का. आप अगर ऐसे कहते हैं कि ये दिस इज अ फैक्ट का मिस्टेक या लॉ का मिस्टेक है, तो ये दिस इज नो डिफेंस और एक्शन ऑफ टॉर्ट. However, in torts requiring malice, such as the wrong of malicious prosecution and deceit, the liability doesn't arise when the defendants act under the honest and mistaken belief. Consolidate Company versus Curtis and Sons, 1892. In this case, an auctioneer auctions certain goods honestly, believing them to be his customers, and pays the sale proceeds to the customer. However, the goods didn't belong to the customer, and the true owner sued the auctioneer. The court found the auctioneer to be liable. Auctioneer को liable ठहराया गया. निजी प्रतिरक्षा. सो आप हिंदी में लिख सकते हैं. ठीक है, विल गो द नेक्स्ट. दैट इज एक्ट कॉजिंग स्लाइट हार्म. ऐसा एक्ट जो स्लाइट हार्म को कॉज करे. डी मिनिमिस नॉन क्यूरेट लेक्स. डी मिनिमिस नॉन क्यूरेट लेक्स. द लॉ डजंट टेक अकाउंट ऑफ ट्रिफल्स. द लॉ डजंट टेक्स अकाउंट ऑफ ट्रिफल्स. फेमस केस लॉ क्या है? कावर्ड वर्सेस बैडले. कावर्ड वर्सेस बैडले 1859 का केस लॉ है. क्या था इसमें? बायस्टैंडर टच्ड अ फायरमैन on the arm to attract his attention to another party of a building where a fire was raging. On a suit filed by the fireman for battery, the court held that the bystander wasn't liable नहीं ठहरा गया for the battery. Next we have is statutory authority. Statutory authority क्या है इसमें? If the legislature has authorized the doing of an act, no action can be maintained for that act. कोई एक्शन नहीं मेंटेन किया जाएगा. किस लॉ केस में? वैगन वर्सेस स्टाफ. वैगन वर्सेस स्टाफ वेल रेल कंपनी. वैगन वर्सेस स्टाफ वेल रेल कंपनी. इंजन स्पार्क केस. इसको एक और नेम से जानते हैं, दैट इज इंजन स्पार्क केस, which is in 1860 around. Sparks from an engine of the respondent rail company set fire to the applicant's woods on the adjoining land, held that since the respondent had taken proper care, even तो proper care लेने के बाद भी हुआ, to prevent the emissions of sparks, it was impossible to totally prevent the escape of sparks. It was an impossible to totally prevent the escape of sparks, and they were doing nothing more than what the statute had authorized them to do. They were not liable. ये liable नहीं थे. केस लॉ क्या है इसमें? Hammersmith Rail Company versus Brand. Hammersmith Rail Company versus Brand. In this case, the value of plaintiff's land depreciated due to noise and smoke caused by the running of the train for the defendant's company. किस company? Defendant's company. The court granted the defense of the statutory authority in this case. सेम थिंग इज़ रिटन इन हिंदी। मैं बार-बार कह रहा हूँ, इसे आप हिंदी में भी पढ़ सकते हैं अगर इफ यू हैव डाउट एनी।